Hey, good morning again, everybody. I'm going to do part two for chapter four. But before I get into that, I'm not suggesting the book is disorganized in any way, but one of the things we get when we read the Constitution, when we read the Bill of Rights, we think we kind of understand what the language means, or we don't. Let's be honest. Sometimes you read uh, the Fourth Amendment, we shall be free from unreasonable searches and seizures on our person, papers, and effect. I think I know what that means. I know what I'd want it to mean. But the reality is, our subjective views of the language aren't always going to prevail. We should look to the document first. We should look to the Constitution and say, these are the words. It's the plain meaning of what these words in the English language mean. Problem is, it's not that clear, and it's subject to interpretation. And the one thing the book does is it breaks out the different chapters in a certain fashion, which I think are fairly logical. But the one thing that I think should have been done a little bit earlier is this concept of judicial review, which will be tested on extensively and we'll cover it extensively later. Kind of wish it was done earlier, because when we go over the Bill of Rights, we think we know what it means to have freedom of speech. We think we know what it means to have the right to bear and keep guns or arms. We think we know what it means to be free from cruel and unusual treatment. Like, I'll give you one of my biases. I'm an anti-death penalty guy, not because I'm like religious or anything like that. I'm a kind of a small government guy. I don't think my government gets a lot of stuff right, and so if it's going to start executing people, I'm not too sure they're getting it right all the time, and I don't think it's equally applied. I mean, I'm not like a zealot over the issue, but so some people that I've dealt with and talked to and say, "Well, I'm also anti-death penalty. Let's be friends, right?" And we start talking, and they say, "Oh, it's so unconstitutional. It's against the Eighth Amendment to the United States Constitution." And I'm a pragmatist and I'm a realist. And I said, "No, it's not." And they said, "Yes, it is." I said, "No, it's not, because the courts have told us it's not." And when the Eighth Amendment was developed, it was developed in a nation that actively used the death penalty. So clearly, when it was written and it was adopted with the expectation that the death penalty be a viable option for the criminal justice system. So I don't argue it based upon the interpretation of the Constitution as it was written. I just don't like it, So, but the Constitution is not a popularity document. It's not a document that always reflects popular views. It's what does it mean? And so, where do we get that meaning? We get it from judicial review. There was a famous case, and this guy should have his face. I know Donald Trump wants a spot up there. I don't know if there's enough room for all of us, but Donald Trump wants to be put on Mount Rushmore. He said that several times. But when I think of a petition to put someone on Mount Rushmore, I think of someone who's had a huge impact on historical developments in our nation. And I think of John Marshall from the United States Supreme Court, not our first Chief Justice, but the most significant ever. No question about it. Greater than any other justice. Why? I'm not saying greater because he was right, but greater because he created the principle really through him and him alone. I know there's other members of the court with him that had to agree, but he was the moving force behind this concept of judicial review. And it came about in a case called Marbury versus Madison. And I don't want to get all the details of Marbury versus Madison. Basically, there was a controversy brought before the court, and the court, although ruled in favor of Thomas Jefferson's view and gave him the outcome he wanted, but in the process, John Marshall said the Constitution is a legal document. The judiciary's role under Article 3 of the United States Constitution is to interpret the law. So, therefore, when the court interprets the Constitution, it is the final arbiter on what the Constitution means. And other than a few isolated cases in history, when the Supreme Court tells us what the Constitution means, we live with that until the court overturns itself or narrows it, or we amend the United States Constitution. That is huge. That wasn't written in the Constitution, this power of judicial review to be able to strike down a federal statute, to strike down a state law, to interpret a meaning that might be seemingly inconsistent with what we think the document should say in terms of application. It's stunning. And that's why we do have the checks and balances we do, because we always are told, well, the court can turn around and strike down an act of the legislature, or the court can turn around and strike down the act of a president as being unconstitutional. It's nowhere written in the Constitution. So where did it come from? It came from this famous case of Marbury versus Madison, where the court basically seized the authority to be the final arbiter in interpreting what the Constitution means. The people really are the final arbiter, because if we don't like what the court does, we can amend the Constitution. But I just went through the last video. We don't amend the Constitution very much, very often, and it's a huge burden to do so. And that's the reason why I bring it up. Is right now Donald Trump has named a candidate to become the next member of the United States Supreme Court, which is his power under the United States Constitution. His only check on him is the United States Senate. But if the Senate approves his choice, that is the new Supreme Court member. Why should we care? Because the members of the Supreme Court will interpret the Constitution to tell us what our civil liberties mean, what our civil rights are, what the federal government can and cannot do, and what we as individual citizens can be free from in terms of unwarranted, or what we think is unwarranted, interference or challenges to our individual activities. And I'm not saying it's good, bad, or otherwise, but that's why the Supreme Court's important. That's why it's important when you vote. You have to consider the same on the state level. When I vote for the governor, I have to think about what kind of judges are they going to likely appoint to the court. On the federal level, same thing. What kind of nominees will be put on the federal bench, especially the United States Supreme Court? What's their sort of litmus test, or what are the rules going to be when they get on there? It's critical, and it's coming out today. So, I mean, as we speak, in the next few weeks, there might be hearings, and you might be able to listen to it at NPR. One of you made a joke. I think it is Cody, and I think he's in this class, made a joke. I don't know if he's in this class or another class. Said, hopefully by going through these classes, he'll understand the jokes on NPR. I thought that was one of the funniest things I ever heard. But NPR isn't just for us egghead nerds. I'm not that much of an egghead, but sometimes they'll hold live these hearings before the Senate with a Supreme Court nominee. And the Kavanaugh one was bizarre because it was all about his sexual behavior when he was in high school. But they also do cover things about what's your judicial philosophy in interpreting a statute? What is the role of the Supreme Court? Do you look at original documents and determine what the original framers meant? Or do you think it's a living, breathing document that should mold and mend and grow and shrink in light of what society needs? And there's nothing in the Constitution that says how we have to interpret the United States Constitution. So the membership makes up the law, and we have to live with it unless we're willing to amend the Constitution. Now, I already spent 8 minutes basically pontificating about the role of the court, but that's important because when we go through the Bill of Rights right now, some of you are going to say, well, this was what it should mean, or this is what I thought it meant. Well, all that really kind of matters, and I hate to kind of cut right to the jugular here, but all that matters is what the court, the United States Supreme Court, has interpreted it to mean. So let's go through it. The First Amendment. No right, and might as well start with this concept first. No right, no civil liberty is absolute. They're all subject to some curtailment under appropriate circumstances. So the one that comes closest to pure, meaning the one that comes closest that the government has to keep its hands off, it's sacrosanct, is freedom of speech. The First Amendment is chock full of rights. The most important, I think, is the freedom of speech, and it relates to freedom of the press. They're interchangeable in many respects, especially for introductory class, might as well treat them as that, because we recognize as a free society, we should be able to speak our minds, redress the government, maybe even criticize the government, although that got debatable later on with the Sedition Act under John Adams. I'm not getting into too much history, but freedom of speech is something that we take a great deal of pride in, and we don't want the government to interfere with that principle. But can it? Yes. No right is absolute. And we know that if you go too far and you actually promote sedition or the overthrow of the government, and it's kind of there's a test that the Supreme Court made up called the clear and present danger, that if you're not just saying that the government should be overthrown, but you're saying the government should be overthrown, and I know where we can get a bunch of weapons, and we can meet up here, and we can start recruiting members, and we can start getting different offices throughout the country to get ready for the overthrow of the country, that could be subject to punishment. And you can't turn around and say, well, I have freedom of speech, and all I was doing was speaking. But if the speaking is such that it endangers the stability of our nation, causes potential violent uprising, causes violence to property or persons, then the government has a right to intercede. But generally speaking, it's the closest we come to a pure right. Freedom of speech can only be curtailed or punished if it really violates others' rights or the stability of our society. and this test is called clear and present danger. It's changed over time. There's a famous case called Shank. It's one of my favorite cases because there's a guy named Eugene Debs that was involved in it. He was initially just a Labor Party guy, but he later became a socialist and a communist. Those are dirty words in our society. At least it was at the close of World War I, and that's when he was around. And he ran for president several times. He was very popular for a period of time. And I collect political memorabilia. You see some of the buttons behind me, and the button I don't have, I thought I had it once, but it's my grandfather's collection and my father's, and now it's mine. And I thought I had a Eugene Debs button, but he ran while he was serving time for what? He was serving time for basically urging World War I enlistees to burn their draft cards and not report to war, because the war was just for capitalism and for all these large money-making entities, and it was just a waste of a human life, and you shouldn't participate. That was deemed to be an impediment to our fighting a war. Our national security was at risk by the things that Eugene Debs and Shanks was saying. And so he got convicted. He got this like really long sentence too. And while he was in prison, he ran for president. And yeah, he didn't win, but he didn't really do that poorly, because initially World War I was very unpopular in our country's history. He got over 1 million votes in that era, and it was quite a surprise. But his political button was Eugene Debs, and it had his inmate number on it. And I thought that was always funny to even take some pride in the fact that you're serving time. Herbert Hoover, always had a tough time saying his name, pardoned him later, so his sentence was greatly abbreviated. But my point is, you can't say everything you want under every circumstance. But for the most part, it's a pretty much wide open theory, and most of us want it to be that way. Even if it's an unpopular concept or idea, we want people to be able to vent those things, especially when it relates to politics, governance, and discussions of things about power and society. We want a free flow of ideas, no matter how repugnant they are. And that brings up the Westboro Baptist Church case. These people were going and protesting on public property about at the funerals and cemetery locations of service people being killed, usually very young people. Their moms and dads were there. They're burying their young loved one. They're heartbroken. And these people are yelling and screaming these really horrible things about how your child had died because of homosexuality that's allowed in our country, and because of other policies that are allowed. It's really repugnant, the things they were saying, and it's horrific. And some of the local governments tried to stop this group. They fought it. They brought it all the way to the Supreme Court, and the Supreme Court in a 7-2 decision. So clearly the law is fairly well established that it's not about the repugnancy of the speech. It's about whether they put anybody in physical danger of violence or overthrow of the government in that moment. That was it a tinderbox? No, it wasn't. And so therefore their freedom of speech was actually violated. And there's other case, one other famous case in the 60s, or actually it might have been the early 70s, Tinker. These kids wore black armbands to protest the Vietnam War, and they wore them in school, but they weren't disrupting the educational function of the school in any way. Teachers could still teach, students could still learn, and these students were kicked out or suspended because they were wearing these black armbands, and that's called symbolic speech. Symbolic speech is just as protected as verbal speech, like burning the American flag. I personally find it repugnant. I don't like it. But the reality is it's symbolic speech, and it is protected. And a free society needs to allow this exchange of ideas, no matter how troubling they are. But because it's not an absolute right, when can we get jailed? Think about it. You can't do sexual harassment. Coworkers of mine can't say things that are inappropriate to me to create a sexually harassing environment, nor I can they. Is that curbing my speech? You bet it is. But are we meeting another greater goal? Yeah, we're trying to protect people from having the chilling effect on being able to work free of that kind of behavior and speech in the community. So sexual speech is often curtailed. Hate speech, using words that we know are likely to trigger violence, is hate speech. That can be curtailed in the right environment. But the big one is time, place, and manner. Think about it. Say we're in a class right now, and I don't know, I'm lecturing about something about voter rights or something like that. And I don't know, 5 or 6 of you start chanting, Trump, Trump, Trump. Re-elect Trump. And I said, wait, okay, great. You got to do that at your own time. Can I kick you out of class? We're a state institution. It applies. Freedom of speech applies in our institution. Yes, I can, because you're interfering with the function of the educational system. Therefore, the college has the ability to control speech in terms of time, place, or manner. They can say things like, you can do that. It's got to be down in the common area or in the student lounge area, and it's got to be at a time that doesn't interfere with people's class instruction or learning environment. But that's often abused by the government. They'll say, oh, yeah, you can have your parade, you can do your march, you can do it at 3 a.m. and you can do it on January 21st, the coldest day of the year, and you can do it behind the gymnasium at Mount Wachusett Community College along the swamp. So no one can hear you, no one can see you, and it's probably going to have a pretty low turnout because they're purposely trying to create, no pun, well, maybe pun intended, a chilling effect on your ability to convey your ideas. That they can't do. But generally speaking, can you control protest and speech, place and manner? Yes, but that's usually the limitation. Content is very rarely curbable unless it's going to lead to imminent violence or the overthrow of the government. Those are pretty rare, very difficult criteria. It's the government's burden to prove it, by the way. And that brings up a concept, and I think I'll probably put one test question on it. It's called prior restraint. If the press is going to publish something and the government thinks we have a compelling reason not to have the press put that out there, like for some reason, maybe the press knows of a secret mission we're doing against terrorists. Obviously, the government has a compelling interest not to allow those articles to be published in the press, but it has to be proven by the government, a very, very heavy burden, that prior restraint is necessary in order to protect human life and safety. And it's very, very difficult. And that happened at Abu Ghraib. If you don't know what that is, there was an American detention center over in, I believe it was in Iraq. It may have been in Kuwait, but I think it was in Iraq, where they had these enemy combatants, and they were doing terrible things to these enemy combatants, meaning they were making them do things while they were naked, and they were humiliating them, and they were making them do sexual inappropriate posturing during photographs. And so all these photographs existed. And I don't know if it was the New York Times, but several of the big major media outlets got a hold of these photographs and they wanted to print them. And the government says, oh no, it's gonna cause the enemy combatants to really want to kill us more even. It's not a strong enough argument. These enemy combatants already wanted to kill us and cause us harm. And there was no immediate danger, although there's humiliation, there was embarrassment, and there was shame, and it did probably undermine the government's credibility, but that's not the test. Prior restraint requires you to prove it's actually going to harm human life and safety more than it already exists. And I think most of us, although we didn't like seeing those images, we like the fact that for the most part, freedom of speech does exist. I'm only 18 minutes in, I've only talked about speech, but it can be curtailed in time, place, and manner, sometimes in content, if it's going to harm either emotionally or physically or cause property damage or imminent violence. It's called the clear and present danger standard. I think there's a movie called that, just to kind of play on words. Our own Justice Oliver Wendell Holmes made that standard right here. It was from Massachusetts originally. But the second part of and there's also freedom of assembly to petition the government. And you're not going to be punished because you're complaining to the government, and you're not going to freedom of assembly. You can decide who to assemble with and who not to assemble with. The next one, in the big one, I'm just trying to cover big nugget stuff, and I can go on and on forever. In fact, we probably should have a course at the college, I think, just on the Bill of Rights, and we could spend ages just on the First Amendment. We could have classes on the First Amendment. The second one, outside of freedom of press and freedom of speech, is religion. And there's two different prongs in it that sometimes actually come into conflict with each other. The first one is freedom of exercise. It's called the exercise prong. We're free to do whatever we want in terms of beliefs. You can believe whatever you want. They can't come in and say, hey, Jim, you believe in worshiping Satan or something like that. That's allowed. It may not make me popular, but it's allowed. I can be a Catholic, a Jew, a Hindu, a Muslim. I can be whatever I want in terms of ideology, and the government can't interfere with that. And that's upheld pretty well, although our nation's history, those of you taking U.S. History 1 know that for a while you actually, in order to participate in some governments, you had to be a member of the Congregational Church, which was the Puritans, or you might have had to have been a member of the Baptist Church in some jurisdiction. That all changed with the First Amendment to the United States Constitution. We want to make it perfectly clear there'd be no litmus test for religious affiliation, and we wanted to make sure people would be prosecuted for their religious beliefs, no matter how unusual to the rest of us. Careful, is there any limitation on the free exercise of religion, which is the identification of religious dogma? Not in terms of your thoughts, but in terms of behaviors. So I can't go up and say, I'm going to take a bunch of kids from the junior high school later and sacrifice them to my gods. Seventh graders are usually the ones that my God is most appeased by. So I'm going to gather maybe a dozen of them because that's the number my God wants. And I'm going to burn them alive at the stake in my backyard. And that'll help bring to fruition my religious beliefs. Obviously, that's not going to be allowed. So the government does have a role. But sometimes it gets a little bit more challenging. Like, what about, okay, at my faith, we slaughter a lamb on the altar. Something to say, well, that the government can stop that. That's cruelty to animals. Actually, that one's going to be allowed. There's case law on it because many of those kinds of religious practices have been recognized in many faiths prior to the existence of the First Amendment and prior to any regulation trying to ban them. So animal sacrifices, generally speaking, are protected under the Free Exercise Clause. And then there's some contradictory ones that came out of the Supreme Court about drug use. Initially, peyote, a certain, I don't even know what it is a mushroom or some kind of plant or something. Native American groups are saying it was part of the religious practice to take peyote. Federal government came down and said, no, you can't do that. It's a violation of the narcotics laws. And it went to the Supreme Court, and the Supreme Court actually said the government did have a greater compelling interest than the religious freedom. That actually got later overturned by a federal statute allowing those Native American groups to use that peyote. But then there's an inconsistent Supreme Court case out of, I think it's Washington State, where there was a hallucinogenic type of tea that was used up in some religious faiths, and the Supreme Court said that was okay. The federal government didn't have enough of a compelling rationale to stop that religious group from using it. It's an interesting thing, and it's not always clear who determines whether something's permissibly allowed under religious practice. It's the Supreme Court. But for the most part, we want people to be able to exercise their religious freely without any persecution from government. Related to it, but seemingly contradictory to it in some ways, it can be contradictory to it, is the Establishment Clause. That's the second prong on religion in the First Amendment. The government, we can't have an official state government like the English have. The Anglican Church is recognized as part of the government's official church. We don't have an official church, and we can't have one. But don't think of it as like a 4-foot, 12-foot high concrete wall between state, meaning government existence, and religion. Think of it more as a chain link fence. There's permeations in it. So when Congress starts off its new session every year, do they start off with a prayer? Yeah, because, well, that's a violation of separation of church and state. It's a Christian prayer, or now they bring in. I went to one at the college one time, a convocation at the graduation, and it wasn't too long after 9/11, and we're trying to deal with sensitivities to all these different religious faiths. It was like a religion show. They had all these different. They had a Muslim cleric. They had I think a Catholic priest. They had a Unitarian church leader. I believe they had a rabbi they had everybody. It was like a religious show. I thought that one went a little bit too far. I thought there was a violation of church and state there because we're a state institution and there was a lot of religion going on that night. But my point is here, the government can't overtly foster one faith over another, nor can they inhibit the faith. And it's complicated because we know that there are many things that related to faith that seem to be related to government. Sometimes there's this thing called the creche scene or the nativity scene you'll often see on the town common. Well, that's town property. That's Christianity there. It's promoting Christianity, isn't it? It should be banned. There's been a lot of case law on that. They say, well, the nativity scene is also part of our cultural heritage and also part of the commercialism of the season, and it helps promote that in the community. It's a fine line. I don't always know the answer of when we crossed over. I know a lot of school districts get really worried during the holiday season. That's what they call it, the holiday musical event that my kid plays his drums in. Or is it the Christmas pageant? You can't call it Christmas, can you? I think the schools overreact. I think they can call it the Christmas pageant, but they don't have to, and they certainly might be offending different groups that don't have Christian views, and so it might be wise not to do that. But we see, like, you can't have a Christmas tree anymore. You got to have a holiday tree or I don't know, season tree. I think people react more strongly than half to the case law allows some overlap as long as it's not doing so much and it's not in the hub of the government's purpose. One I can tell you about, there's a guy out of Alabama or Mississippi. He ran for state senate. He was the head of the Supreme Court there. He used to keep the 10 Commandments right up on like a big placard right behind his chair while he sat on the bench. People objected to it and said that's too close a relationship between church and state, and they want it taken down. That went to the United States Supreme Court. The United States Supreme Court says he has to take it down. In fact, he was actually removed from office because he refused to take it down. There's a test. And I always thought the lemon test was funny because, why do they call it the lemon test? Well, one of the litigants in it was lemon. And I think it's one of the best examples of the challenge of trying to figure out how do we make the balance work. And it's not a clear test. And I could put this in front of 100 different scholars in 100 different circumstances, and we're going to come to different conclusions. We constantly litigate this question. Things like, I don't know if I have a dollar bill here. It says right on the dollar bill, doesn't it? Under God, right? Or in God we trust. On the coins, I think under God, e pluribus unum, under God. And Teddy Roosevelt had it taken off the money for a period of time. If you're into coins like I am, there was a period of time that he thought it was repugnant to faith to have that kind of a terminology on money. But the point is people say that taking the oath, it's just under God, we should have that removed from doing our Pledge of Allegiance. Pledge of Allegiance, for crying out loud, arguably is violating civil liberties in some ways. And those things get litigated all the time. And because there's a historical backdrop to it, there's a cultural backdrop to it, and it's not advocating one God over another, there's an argument that it doesn't violate the separation between church and state. Others say it does, especially those of you that are agnostic or atheist or don't believe that God should ever be, or religious ideology should ever have anything to do with the symbolism of government. It's a tough question. But what the court came to, and this would be on the test, the lemon test. The lemon test said the law, if it somehow seems like money's flowing to a Catholic school or something like that, or the government's working hand in hand with different charitable organizations, that's an extension of different religious groups. People argue, does that go too far? Is it really a violation of the Establishment Clause? And here's the test that came up in this famous case, the lemon test. It's still applicable today. They still use it. The action or law must not lead to excessive government entanglement in the religion. In other words, policing the boundary between government and religion should be relatively straightforward and not require extensive government effort by the government. 2, the action or law cannot either inhibit, meaning it can't put a chilling effect on the religion, nor can it advance the religious practice. It should be neutral in its goal. The action or law must have some secular purpose. There must be some non-religious justification for the law. So sometimes we have these, I don't know if we have them here in Massachusetts, but they had these vouchers where, you're not comfortable taking your kid to the public school. You can take the voucher, and now you can send your kid to Catholic school. Well, by giving the Catholic school the money, aren't you helping to promote the religious faith? That's the analysis you go through. I don't always know the answer on that one. Hey, that's the First Amendment. We're in a half hour. I'm killing you, I know. But this is tough stuff, and the book is very good, and I hope you enjoy it. And there's all kinds of books just on the First Amendment, freedom of speech, freedom of press, freedom of religious practice, and freedom of keeping the government outside of promoting one religion over another, or inhibiting one over the other. It's very important. I'm not going to spend too much time on the Second Amendment, but some of you are really into it. Hey, I'm a gun guy too. I've got guns. I don't think I'm a gun nut, but the Second Amendment is basically the right to keep and bear arms in a well-regulated militia. Now, some people say, well, if you're not in a well-regulated militia, the amendment shouldn't apply. But when that was written, the concept of militia was basically citizenry. And so the Supreme Court took a look at that and said, well, it's not really hooked into it the way one might read today. So there is a right to keep and bear arms, but is it for everybody? No, we recognize, and the Supreme Court has recognized, some people should be kept from keeping and bearing arms, usually convicted felons of violent crimes. Those people shouldn't be. But other people here say, wait a minute, you did your time, you're back in the community, you should be able to have the same rights as everybody else. But again, no right is absolute. And the same thing is, what does it mean, the right to keep and bear arms? Some people, well, during the time it was written, all we had were these muskets. You should only be able to possess a musket. But isn't there an expectation the Constitution is applicable contextually in terms of our time? So can we have machine guns? Can I have some hand grenades in my collection? We recognize there has to be a reasonable process by the government, and that tension's going on all the time. There's new cases coming all the time. Can I have a gun that has a capacity over 10 rounds before I have to reload? Can I carry the gun into certain municipal or governmental buildings, or am I barred from doing that? Do I have to take a safety course before I possess a gun? Can I have a fully automatic gun versus a semi-automatic? That tension between the right and government legitimate curtailment is always in tension on the Second Amendment. And those of my buddies who are, real gun nuts think it should be unfettered and government should have anything to do with the kind and nature of the guns I own and possess and how many. And there's other people on the other side of the argument that I've talked to saying, hey, in order to cut back on gun violence and or threats to the stability of society, we have to have reasonable gun regulations. And that tension's always there. That's the political tension. The court tells us what flies and what doesn't. And this is another thing under federalism. We know there's a federal standard, but many of the states, you can't go below the federal standard. The federal creates a certain level of civil liberties that's recognized under the Constitution. The states can't go below that. The states can go above it. And that's an interesting dichotomy. We know Massachusetts is a very, very heavily regulated state when it comes to gun laws. Vermont, New Hampshire, and Maine, not so much. And I have friends of mine that are so into guns, I'm thinking about moving up there. I don't know if I'd move over a gun issue. Some of you might. Some of you are very, and that's one of the part of things coming up in the next political election. A lot of people talk about, this candidate's more pro, I hate to call it pro Second Amendment, because the Second Amendment would ever mean the court tells us to mean, not what so much the president does. But, is one going to be more likely to try to regulate the possession of arms and weapons more than the other candidates? Yeah, they do. They have different philosophies on it. But I don't want to spend too much. Third Amendment's not going to come up. This was big, though, in colonial times. They call them lobster backs. If you look at a British soldier in their red uniforms and the way the tail's kicked out at the end, if you look at a lobster back, it looks kind of like a lobster, especially with the red, if you get it after a good boil. The lobster backs were housed in many citizens' homes just prior to the breakout of the Civil War and during this Revolutionary War, kind of a Civil War, but the Revolutionary War. And not only they were housed in private citizens' homes, the private citizens would often have to give them food and shelter for free. And many of these soldiers, when their time was free, would actually compete for employment and other goods and services in the community. And it really was repugnant. And it doesn't come up anymore, but boy, in that era, that was like a big deal. We better put an amendment in the Constitution. The quartering of soldiers can't happen in private citizens' home without their consent, obviously. Now the Fourth, Fifth, and Sixth Amendments, these are my amendments, I was about to say. But I practice criminal defense and they come up quite a bit. Now, careful. Some of you don't like that. Say, the criminals get all these rights. Well, they're not criminals until their conviction. Let's make sure they are criminals. And that's what the Fourth, Fifth, and Sixth Amendment provides for, is protections from government overreach and to ensure that those have done a crime are actually guilty of those crimes. It's about giving integrity in the system. Are most people charged with a crime guilty? Yeah, but are some not? Yes, and that's why that discussion board, I think it's a discussion board question I put up, why is it better to let 100 guilty people free than to have one innocent person suffer the persecution of an unjust conviction? And that's the society we live by. Democracy is a bit dirty on that level. But the Fourth Amendment is we have to be free from unreasonable searches and seizures. Early on, a lot of people thought that meant on every search the government, the federal government, and later the state, had to be supported by a search warrant. We know that became impracticable. You have to have an ability, police officers, when you're stopping someone on the side of the road or in a car or walking down the street, there may be a necessity to search that person for the protection of the officer and the public around. And also they may have something called probable cause that they're hiding something on their persons or in their vehicle that's related to criminality. A warrant is always preferred, but if a warrant is going to be given, it has to be given by whom? A neutral and detached magistrate. We don't want another cop giving the decision. Yeah, go ahead, search that home. We want it to be given by a neutral, detached magistrate, and it's got to be based upon what? Probable cause. And the courts over time, meaning that it has to have a strong probability that the facts alluded to by the law enforcement official suggest that there's criminality occurring in a certain location, and there's a need to search and seize persons or things in order to stop that bad behavior. Those that are out without a warrant are presumptively invalid, and it's the government's burden to show why there's an exigent circumstances. Person's running down the street. If I have to wait for a warrant, I'm going to have to let him go. There's a person screaming in the house, this guy's stabbing me, come save me. I better go get a warrant. No, you can go in and search to save someone's life because it's reasonable based on the probability that someone's about to be killed and criminality is about to take place. I don't always know the parameters, but I love the Fourth Amendment. Not that I'm a criminal in any means, but it protects me from knowing that law enforcement is not just going to come through here and do a sweep like the British military and authorities were doing to the colonialists during that era. It's so repugnant to our sanctity, especially in a home. That's the highest degree of privacy expectation we have is in our home. We want them to come in with a warrant, and very rarely is a home search valid by law enforcement unless it's done with a warrant, because very rarely is there an emergency. But imagine right now, my daughter's yelling out the window, he's killing me, and a cop hears it. Shouldn't the cop be able to search right now and then to make sure that person is protected, even without a warrant? Yeah, it's all contextual. And what does the Fourth Amendment mean in different contexts? It's all depending on what the court says. So I'm constantly looking up case law on things like, when did law enforcement have the right to search the trunk of a motor vehicle? When does law enforcement have the right to search a home, an individual person walking down the street? What is reasonable suspicion to detain a person? Because stopping somebody on the street is a type of seizure of that person. And it's funny to me. I look at my haircut. I wear glasses. I'm old. I don't get stopped by the cops on the street. But when I was younger, I had very, very long, orange, curly hair. And I hung around with working class sort of guys in bad areas, and we used to get stopped all the time. And we used to think they were doing the right thing. They didn't have a right to stop us. But now there's some new case law that came down in Massachusetts, which I support 100%, that African-American youth in Boston that ran from the police, who fit a very vague description of people that might have been breaking into homes, the police officers couldn't use the fleeing as evidence of their need to stop and seize them, because African-American youth have been so historically harassed by cops that their fleeing might be a natural tendency to avoid being harassed. This is what keeps us free. But law enforcement, and this is the argument on this side, law enforcement often gets stymied because they can't search when they know, based upon the communities they work in, that they could really ferret out a lot more crime if they could stop people and do a quick search to keep everybody else safe. But if I'm the one being searched chronically and I haven't done anything wrong, I don't feel like I live in a very free society. Do I? And that's the kind of argument we have going back and forth. Now, the one rule that's really changing over time is, okay, so say a police officer does, in good faith though, they search me, they don't have probable cause, they see I got some sticker that says question authority in the back of my car, I don't know, I'm playing inappropriate music, I have loud, I look like I'm in the wrong neighborhood. So they pull me over and they search me, and they go into my trunk and they find a bunch of cocaine and a bunch of illegal firearms. If the search is illegal, it's nowhere in the Constitution. This developed through case law, through the Supreme Court. We've created a rule called the suppression of evidence, or the fruit of the poisonous tree, because we don't want law enforcement to benefit by their illegality, their violation of the Fourth Amendment. We throw out that evidence. That's actually shrunk quite a bit on the federal level, because now there's all kinds of exceptions like good faith, inevitable discovery, consent. All these different kinds of exceptions have really carved out, making the fruit of the poisonous tree, the suppression concept, very anemic, very weak right now. But on the state level, the suppression rule is very healthy. So if law enforcement, even if in good faith, search my car illegally, but on a good faith belief that they had a right to do it, they weren't trying to violate my civil rights, but they did, that evidence will be suppressed and thrown out. And we've let and that's what people think of as a technicality. Well, we're letting this defendant go because of a technicality. And quite frankly, I would say a third of my victories in court is because I'm able to keep out evidence that was invalidly attained under the Fourth Amendment to the United States Constitution, or under the Massachusetts Constitution, Article 14. And it is a technicality, and my client may have had possession of illegal items, but the search and the stop was unconstitutional. You can't benefit from illegality in your prosecution of defendants. I have mixed feelings about it even too, even though I'm very, I'm a civil libertarian I'm a criminal defense attorney. But when I have, just a quick aside, I think a funnier story, back when marijuana was bad in the 1990s, I had a case where these guys were in a van and they had bales of marijuana, and a lot of marijuana. And we were in front of a pretty conservative justice, but man, the search was so bad. And the cop was so honest. It's great. A lot of everyone thinks cops are liars. The cop was, yeah, kids, you could tell they're kids. And they got the mystery van out there, and it was painted with all these hippie colors. And they had long hair. I had a hunch they were up to no good. And then we asked them, did you have any proof? No. Did you smell marijuana? No. I just had a hunch and I was right. I searched their van and I got over 70 pounds of marijuana or something like that. The judge threw out the evidence, and rightly so, because it was an illegal search, both under the Fourth Amendment, the 14th, Article 14 of the Massachusetts Constitution. But I always remember this judge who's now retired. He's still alive. And there's another funny story with that. I thought he was dead, and I saw him at a funeral for somebody else, or wake. And I saw him, hey, Judge, hey, how you doing? He goes, good. Geez, I thought you were dead. You look great. He said, well, wise guy. I thought he was dead, but he did look great. But he threw out the evidence, and the case is basically dismissed because they can't prosecute without the evidence. And guess what my client whispered in my ear relatively loudly that the judge could hear. He goes, do I get my weed back, man? No, you don't get your weed back. These people are unbelievable. And the judge screamed at me like somehow I was at fault for asking that question. But anyways, the Fourth Amendment keeps citizens free from unwarranted searches and seizures. And most of us that aren't committing crimes can imagine how repugnant it is to be searched. And who is going to be searched? The poor, minorities. And I'm not saying this because I'm to get people all riled up and angry. It's just a reality. If you live in a poor community, if you're of a certain race or ethnicity, if you keep your clothes in a certain way, if you're of a certain age, you're more likely to be subject to searches. And I tell you, it's got to be repugnant to you to be searched and harassed when you're not doing anything wrong. And that's why we have these rules curtailing it. And I'm glad we do. The Fifth Amendment's a big one. This is basically has a couple. One's double jeopardy. I won't spend too much time on it, but you can't be tried to a verdict in the same jurisdiction for the same offense. So if I'm found not guilty, I always use the OJ example. OJ's getting old now, but back in the day when I was first practicing, it was a big case. OJ's found not guilty of first-degree murder in the state of California. Later, they find new evidence. Can they go back and try him again? No. Double jeopardy prevents that, because think of what the colonists were worried about. Many of the colonists that were agitating for revolution, they were getting charged with certain crimes. The local juries were finding them not guilty. And what did the British Crown go and do? They go retry them again. You had your bite at the apple. It's over. Double jeopardy is an important concept, because think about it. The government might keep coming back after you. That doesn't mean if you're charged in the state court, you're found not guilty. The federal if there's a federal statute that deals with the same question, you could still be charged under the same facts. It's a different offense in a different jurisdiction. Double jeopardy wouldn't apply. And double jeopardy only applies if there's been a verdict. Sometimes in the middle of a trial, there's a mistrial. The jurors don't do something inappropriate, or there's a hung jury. They can't come to a conviction. That defendant can be tried again in the same jurisdiction on the same charge, because there's no verdict. It's only after verdict does double jeopardy apply. A lot of people like to talk about double jeopardy. I think there's movies made about it all the time. It's on every freaking one of these cop shows all the time. Someone's found not guilty and they come out and they tell their lawyer, they basically advertise the fact that they did the crime. Are they free from further prosecution? Yes, in that jurisdiction for that charge they are, but now they might be charged with perjury, or they can still be sued civilly. It's not applicable to civil law. It's only applicable to criminal law, double jeopardy. The bigger ones in Fifth Amendment is the right to remain silent. And most people, even Trump says this, even though he's taken the Fifth Amendment himself in a few civil cases. It's only popular when it benefits you, and when it doesn't, you say the people that use it must be bad. I think it's an important tool. I've used it a lot in my practice, because sometimes people are involved in things that make them look very bad, but it doesn't mean they're involved in actual criminal behavior in terms of what the target of the government is. So my point is, if the law enforcement wants to talk to you, and it could potentially lead to some criminal charge, maybe totally unrelated to why they want to talk to you, you have a right to remain silent. That privilege is very, very important, because that way the government can't harass you. And what do we know the government's done? And I love our country. I really do. I'm very proud to be an American, and I'm proud of the aspirations that our Constitution holds out. But our government has had a history of manipulating and cajoling and making promises and using trickery to get people to confess to things that they didn't do. So the point is by giving people the ability to say, I don't wish to talk to you, it curtails, it puts a prophylactic, it puts a barrier between law enforcement being able to basically cajole or basically get a confession out of you under duress. And we know there's many of them. Many people throughout history, some recent history, where people have confessed to things that they clearly did not do, either to protect somebody else or because of fear in promises that were made to you if you did confess that things would go better for you, even though you're not nearly guilty. I had one not that long ago where a guy says, I just want to resolve my case. I didn't do it. I said, well, you got me. I'm not going to do it. You can get a different attorney. But if you're telling me you didn't do it and you're going to go up there and say you did just because you want to resolve the case, I refuse to do it. And it was one of my better cases in the sense that the client really believed in me. And we actually got an acquittal. He was found not guilty in the case. It's sad, but the Fifth Amendment's necessary to protect people who aren't charged with crimes from saying things that are inappropriate. One movie I always hated, this video's gonna go way too long. I never watched it until like 15 years after it was out, and that was My Cousin Vinny. But there's a great scene in there where he's talking to the cop, and the cop says, and you killed so-and-so? And the kid just out of nerves goes, I killed so-and-so? That sounds like a confession, right? The point is talking to the law enforcement as a criminal defendant suspect is usually not a good idea because things can usually be used in such a way to harm you. So you have the Fifth Amendment privilege to remain silent. I'm trying to think if there's any more. That's a big one too. And you can't be deprived of life, liberty, or property without due process of law. That becomes big time incorporated in the 14th Amendment. That's used more often. But think about it. In order to punish you, to put you in jail, to sanction you, due process, which has been interpreted that the process has to be public, it has to be fair, it has to be open, is a necessary ingredient for our judicial system. And I think I'll just agree to that. The other one's about taking property. The government can take your property, but it has to be after a hearing, due process, and you have to get just compensation. So if they want to take my house or my land here to put a new highway through or to build a hospital or something like that, they can, but they have to compensate me. And we have to have a hearing to ensure what they're doing is related to public benefit. Fifth Amendment's a big one for those of you that are criminal justice majors. And people say, well, Miranda, where does Miranda fit in there? Miranda, again, is a Supreme Court case to say to give meaning and to breathe life into the Fifth Amendment. Most people don't have basic civic knowledge, and so in order for them to know they have a right to an attorney and all these other amendments, the Sixth Amendment being applicable too, and the right to remain silent, you have to be told that. Otherwise, it's too easy to give up a right you don't know you have. And it's sad, but we as American citizens, especially those that are usually subject to criminal prosecution, don't know they have that right. So in order to ensure its integrity, cops have to tell it to them. And I always urge police officers, always read from the card, because in the heat of the moment, you may not remember all the details of it. The right to silence is a big one. You can't be witnesses against yourself. You don't have to testify. Double Jeopardy, big one. A lot of court cases on that one. The Sixth Amendment is the biggest amendment for all the court cases. It has the right to an attorney, not just an attorney in a criminal case. For a long time, states did not have to provide an attorney for indigent people. It says here right in the Sixth Amendment it does. Not until the 1950s did it become incorporated in a case called Gideon versus Wainwright. And I'm going to put a little video up. It's excellent, made by a guy right from Massachusetts who's now dead. He wrote a book called Gideon's Trumpet. This guy was down in Florida, got charged with a crime. Says, I need an attorney. I'm an idiot. Well, he was. He didn't have much of an education. He wasn't very bright, but he was bright enough to know he needed an attorney, or he was going to get, screwed. He was going to lose a case very easily. Judge says, I can't give you an attorney. You can hire one, but I can't give you one. There's no provision in the Constitution that's applicable in the state of Florida to give you an attorney. So he took it all the way to the Supreme Court. Supreme Court says, in order to give meaning to the right of counsel in the Sixth Amendment, it has to be provided for indigent people in criminal cases where you can lose liberty. Got to remember those two caveats: criminal case and where you can lose liberty. So if you're going through a divorce, things like that, or you're being sued civilly over a personal injury case, you don't have a right to a court-appointed attorney there. And you don't have a right to a court-appointed attorney in a criminal case where there's no risk of losing your liberty. In most cases, you do have a risk. So another one, you have to be tried in a location where it occurred. That's a venue question. So say I committed an act of criminality in Gardner, Massachusetts. I shouldn't be tried in some state court in Oklahoma because the government might deem they have an advantage there. We want to be tried in the community where the alleged events occurred. We can always change that voluntarily and by a request of the court if we think we can't get a fair trial there. But I have the right to be tried in the community where the alleged crime has been committed. I have to be informed of the nature of the crime. People are held all the time. What am I charged with? You have to be told what you're charged with. How do you defend yourself if you don't know what you're being charged with? That's sometimes some of these terrorist people that we arrest. We think they're involved in terrorism. We have to articulate a charge against them because it's an unconstitutional holding of someone because we're not giving them the nature of the reason for their detention. Got to tell people what they're being held for so you can prepare appropriately. This is the big one. You got to be confronted with the witnesses against you. This is why hearsay comes up a lot. Those of you that are CJ managers, you should know this as a citizen. Someone charged me with a crime. Who? I get to know who's charging me, who's alleging I've done something wrong. And what else am I allowed to do? They have to come to court and testify in a public forum, public trial. And I can confront the witnesses against me. I can say, isn't it true? I was having an affair with your wife, and that's the only reason why you said I stole these things out of your shed. You're doing it out of revenge. It's not true. And if you watch that movie, My Cousin Vinny again, you'll see that whole aspect of where the right of confrontation helps bring integrity in our adversarial system of justice, because sometimes people do fall apart about what they really saw or heard. And I had a trial, and believe me, it wasn't because I was good. It just came out where I had a guy, an older guy, and he's up on the stand, and it wasn't a criminal case, but it's still the same concept. I said, what next happened? He goes, well, then the car came screeching around the corner and it jammed into me. And I said, oh, geez. I said, and so you saw the car coming around the corner? He goes, no, my wife told me that's what happened. Oh, my God. I objected. I asked if you've stricken from the record. We had a mistrial over it, and we got to try it. We ended up settling the case. But the point is sometimes people, not because of evil or ill will, don't necessarily have the perspective they think they have or the knowledge they think they have. And so they have to come into court and testify in open forum where the defendant has a right to cross-examine and probe them about the truthfulness, the veracity, the ability to perceive, hear, smell, and all those things. Because it's not always about lying. It's always about memory. Oh, yeah, I forgot about that. I didn't really know that. Yeah. So to confront the witnesses against them is the biggest one. And sometimes like little kids are, this sounds terrible, but little kids are victims of crimes. And they don't want to have the little kid come up to the stand, some 12-year-old kid to say that this person did something inappropriate to them. We want to protect those kids. I get that. But if you're the one accused of having done that to that child has to come to court. They can't bring in their statement. They can't bring in a video of them because that violates the Sixth Amendment right of confrontation. And I know that troubles a lot of people, but the fact is democracy has certain warts and inclusions and challenges, but it's to create a better protection for those accused of a crime. Now, I know many of you will never be accused of those things, but I've had people accused of certain things. And boy, if I couldn't confront the things they said, you'd be surprised. And I don't want to tell the story here because the video is running long, but I did have one where it was a sexual assault trial. It turned out the person that was testifying was, I said, isn't it true that everything you're saying today was told to you by the prosecutor? This person had diminished capacity. He goes, yeah, they told me what to say. I said, and then the event supposedly happened in July, and I said, he dragged you through the snow that day, didn't he? Yes, he dragged me through the snow. And then I just on a whim, I said, and he stabbed you at one point in your leg. I just threw it out there. He goes, yeah, he stabbed me. I got the case thrown out right in the moment. Not because it didn't happen, but you have to have proof beyond a reasonable doubt to convict somebody of a crime. And by being able to confront that witness, the truth was unknown. They didn't bear their burden. Anyways, I probably should erase that. But I want you to know that by confronting witnesses, sometimes things come out differently than what we expect them to come out. I hear it all the time. So-and-so said you did this. So-and-so. Well, let's bring so-and-so in here. Let's have them out here. Let's talk about it. Compulsory process for obtaining witnesses on your behalf. That's not talked about too much, but think about it. My client's charged with a certain crime. We know what the witnesses are by the government against them, but I have certain witnesses that I think were there. I need a process to force them to come to court to testify, and the government has to supply funds and the ability to marshal those witnesses in with subpoenas and summons. It's an important tool. And then the next one, to have the assistance of counsel. I don't think attorneys are all that bright, but we know the rules. It's like the first time you play Monopoly, or if you ever play chess for the first time, if you don't know the rules and how the pieces moved, you can be made to look like a fool. It's not that you're a fool, you're ignorant of the rules. So in order to be in the criminal process to really have fair play, both sides should have competent counsel. This brings up a whole nother debate. Public defenders, are they that good? I think most of them are actually very good. But let's think about it. Who gets the best attorneys? If you're very wealthy, you're going to hire what? You're going to hire the most skilled, famous, and expensive attorneys there are. Is that equality of justice? I don't know. But that's the problem. You're entitled to an attorney to be appointed to you at no cost to yourselves. But the Sixth Amendment is a big one. The other is a public and speedy trial. They can't hold you forever. You're entitled to a speedy trial. We have statutes to determine what a speedy trial is, and by a jury, not of your peers. I don't know where that comes. Well, that comes from some of the Federalist Papers about being your peers. But more importantly, is impartial. If it's your peers, I don't know. When I think of my peers, I think of people that are like me, which you're gonna have to go to outer space to Mars to get people like me. I'm very eccentric. I'm a little unusual, right? And so you're not going to find someone. I'm not going to find 6 people in the district court or 12 people in the superior court to be my peers, the people like me. And so that brings up a big debate. If I have an African American defendant, wouldn't it be a trial of their peers to have a few African Americans representing sort of a reflection of who they are in terms of identity? If you're a female, if you're of a certain age, if you're of a certain religion, all of those things are arguable. I had a jury trial not too long ago. I had a African American male as a defendant. And when I mean African American, he's from Africa. He's not even a citizen of the United States. And we had a jury of a mix of men and women, all white. No one of color of any ethnic. These were all very white. And he was mad as hell. And I noted my objection on the record. But the judge says, Mr. Corman, at sidebar, he goes, Mr. Corman, nowhere in the Constitution does it says he has to have a jury of his peers. It says he has to have an impartial jury. They said, Your Honor, I know, but it seems that there should be some reflection of a more diverse jury body in order to have a fair trial. He goes, your objection's noted. Luckily, we won that trial, so it didn't become an issue for appeal. But these things are still being debated quite a bit in society. What does it mean to have an impartial jury? Should it be of your peers? I know it's a debate. But impartial means they haven't prejudged the case. They're not going to like my client or dislike my client because of their identity. They know nothing about the facts already. Or if they do know things about the facts, they haven't prejudged the matter. Sixth Amendment's a huge one. Seventh Amendment, and I know I'm going over these very quick, I apologize. But Seventh Amendment, you still have a right in most civil cases to have a jury trial if it was recognized at common law, meaning when the Constitution and the Bill of Rights were written in 1791, did jury trial rights exist for these kinds of civil claims that were worth at least $20? Like family law divorces were never recognized to have a right to a jury trial, and they still aren't. But most civil cases, you do get the right to a jury trial. Personal injury case, breach of contract cases, you can ask for a jury trial in those circumstances. That's the Seventh Amendment. The Eighth Amendment, which I love talking about, there's 2 big elements there. One is there's no excessive bail. If I'm charged for a crime right now, I should maintain my liberty until I'm convicted. Bail is determined to make sure I'm not a flight risk. That's all it is. So if I have strong ties to the community, I've always lived in Massachusetts, my family's in Massachusetts, my employment's in Massachusetts, and I've had maybe some other criminal cases where I've appeared for court and therefore don't look like I'm a flight risk, there should either be no bail or a very low bail. Obviously, the more serious the crime, the more likely I'm going to maybe try to flee and not face justice. So that's why we sometimes don't allow bail for things like murder or other very serious charges. Often don't have bail eligibility because they're just deemed too serious, not because you're a threat to the community, but because you're more likely to flee. I'm a big believer in letting people maintain their liberty. Unlike my father, we used to have these arguments all the time, and we used to get these comical things where I actually bumped into a person on the street, very rough, fumbled. They looked like a criminal defendant, for lack of a better way to say. And it was with my dad. I goes, who the hell is that? Some guy I represent him. He goes, why is he not in jail? He goes, well, he's out on bail. And he goes, God, look at him. I can tell he's about to commit another crime. And I said, you can? Well, you're clairvoyant, Dad? And we'd have these arguments all the time. He's a little bit more conservative than I am. He says, actually, the guy did go and commit another crime later that week. But anyways, at the moment he didn't. And I argued with my father. I says, once he's convicted, Dad, let's hope the criminal justice system punishes him harshly. But until he's convicted, we live in a free society, and he's presumed innocent, and that's a presumption that's found not in the language of the Constitution, but through court interpretations. We know we have the presumption of innocence that follows us. But the Eighth Amendment is there should be no excessive bails. People shouldn't be just locked up all the time. Otherwise, government would harass the unpopular people of our society and hold them without right to bail. But I have a client right now held on bail, and it's traumatic because most of the offenses are very minor. But what did she do? She kept committing more crimes while she was on bail on the other ones. And it's considered to be constitutional that it's not excessive bail to revoke someone's bail if they're committing new crimes and there's a probable cause that they have committed those new crimes. I don't like that area of the law, but that is the law. So no excessive bails. And there's another whole section that's not in the Constitution, but it's been deemed to be constitutional, that if you're a danger to the community, it's called the Dangerousness Hearing. You were out caught, you were shooting at people with a gun, and you have other gun charges on your record in the past, and maybe somebody was actually shot. Hopefully they didn't die, but you put them in the hospital, and you're involved in gang activity and all kinds of other activity. If the court concludes by a clear and convincing evidence that you're a danger to community, you can be held without bail for up to 120 days in Massachusetts, and most states have a similar provision. Remember, the Constitution is not a suicide compact. We have to have the ability to work around it to protect society, but it's got to be narrowly framed to make sure you have a hearing on that, whether in fact you are a dangerousness person or not. So that's the Eighth Amendment. The Ninth Amendment, I didn't finish the Eighth Amendment. The second one's really big. No cruel and unusual punishments. This one we can debate about all day long. Now, we know when the Eighth Amendment was developed that the death penalty was totally valid. And so when the framers wrote the Constitution, they didn't mean to ban the death penalty. So we're more likely to get in debates about how the death penalty is actually implemented. Is electrocution cruel? Is shooting someone with drugs to extinguish them, I don't know how to say it well, cruel or unusual? Is hanging cruel or unusual? Is drawing and quartering cruel and unusual? Is sticking someone in a tub of sulfuric acid? I think sulfuric acid burns skin. Obviously, boiling oil. At some point, drowning them, tying to a bunch of rocks and throwing them overboard in a rowboat. To me, watching I don't want to sound offensive. Certain television shows I can't stand watching it. That would be cruel and unusual punishment. So the court tells us what's cruel and unusual, and we have these debates in and out, but it's the court that ultimately defines what it is. Every so often I'll hear of a story, someone's sentenced to wear like a big sandwich board sign saying I'm an idiot because I was texting while driving and I injured a young kid. I'm a moron. That's unusual. But usually what the judge will do to get around the Eighth Amendment will say, I'm going to give you 6 months in the House of Correction. Or if you elect by your free and voluntary choice to go around and speak or wear these, embarrassing signs, that's how we'll get around the unusual aspect of the bar on the Eighth Amendment to the United States Constitution. Most of us, when we're a victim of crime, we want the most severe punishment. I get it. I do too. But at the same time, in order to keep a society to have humility and humanitarian dignity, we have to have this balance, and the Eighth Amendment provides for it. The Ninth Amendment is something that's not talked about too much. The Ninth Amendment basically is saying, hey, we've granted the federal government, or we listed certain rights, but those that we didn't list, we still retain. The people still retain them. Because there's a whole bunch of other rights. We just don't have the time to list them all. So just because we didn't list them doesn't mean they don't exist. And that's where oftentimes privacy rights have come out of the Ninth Amendment. There's a famous case, Connecticut versus Griswold. A woman got convicted of having birth control of some kind. It was banned at a time in Connecticut, early 70s, I think. And I think she was an editor of a newspaper. They did it as a publicity, I don't want to say stunt, but to bring it to a challenge. She got arrested and she brought it all the way to the Supreme Court. And the Supreme Court says, the right to privacy in terms of reproductive applications by adults with their medical care provider has no role of government interference, and therefore it's a violation of the Ninth Amendment. To me, if I were on the Supreme Court, I would use the Ninth Amendment much more often. It doesn't come up very much, but man, think about the language there. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people that have always historically been recognized as being part of what it means to be inalienable human rights. Man, if I were the Supreme Court, I'd be jumping all over the Ninth Amendment, using it day in and day out. It just hasn't come up that much, and maybe now in the future it would. I don't know. The court's getting a little more conservative, and they're probably more likely to bend more towards government goals and interests than private rights. But it's interesting. The 10th Amendment, although it's in the first 10 amendments, is more about states' rights versus federal power because, again, the anti-federalists were really scared that the government was going to take away too much state autonomy, and we didn't want that. So the 10th Amendment says the reserved powers, things that we enumerated certain things to the federal government, those that are retained by the states and the people. And we fought a civil war over that in the 1860s, so it didn't really work. But those are the my little quick summary, man, it took me over an hour to blah, 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 blah. But this is like if we were sitting in class, right? Not that much different. We can debate and discuss them some more. Don't be afraid to give some shout outs on this stuff. This is important stuff. And chapter 5 is going to relate a lot to it as well, because the government sometimes takes steps to make sure we have not equality of outcome, but in terms of equality of access to our rights and privileges in our country. And we've gotten much further along, even though we're in really tumultuous times. If you look through history, we've come a long way, got a long way to go, but the Constitution helps us get much closer to those aspirations that we have in um, our Declaration of Independence. It's closer to fruition than it ever has been, and hopefully we'll keep getting closer. Be well.